Hello and welcome to all who is present. Honorable Mr. Justice M.S.Shah sir, Dr. Vidisha ma'am, all the participants, all the viewers who have joined us today for the expert session on judgment writing skills, which will be delivered by Honorable Mr. Justice M.S.Shah sir, and which will be followed by the National Virtual Judgment Writing Competition 2023. It is truly said by Socrates that a judge's duty is to render a justice. And he describes justice as the work of the judge is to hear the courteously. It is to proceed, the judge has to proceed wisely, and it has to consider everything very soberly. With all this great, uh, I would like to invite Assistant Professor of Faculty of Law, GLS University, Dr. Vidisha ma'am, for offer a welcome address to Honorable Mr. Justice M.S.Shah sir.
Very good morning, sir. Honorable Mr. Justice M.S. Shah, sir, former Chief Justice, Mumbai High Court, uh, and before that, the former Chief Justice of Kolkata High Court. Sir, we heartily welcome you on this event of judgment writing, the declaration ceremony. Um, Sir is an exceptional judge and a keen interest in the academics. So, sir, we heartily welcome you. And our student will be very fortunate enough to get a guidance. They will be inspired. All the student, the participant will be inspired by your enlightening the lecture. And sir, just to appraise you, the judgments were judged by Honorable Mr. Justice A.L. Dave, sir. Sir has evaluated the judgment, and to our participants also, it is very minutely been evaluated. Each and every aspect has been evaluated by the former judge of High Court of Gujarat. Here today we heartily welcome, and sir, we as we all are aware, the participants and the viewers are aware that judgment writing is such an important task. It from the subordinate court to Supreme Court. So many students, when they take a law, their aspiration is to become a judge. So, sir, it will be a great help to the students, the viewers. So we heartily welcome, sir, you and all the viewers and the participants of today's online session. Over to you, Gia, ma'am.
Thank you, Vidhi ma'am, for your warm welcome address. Now, I would like to invite Neha Burani, who is Assistant Professor at GLS University Faculty of Law, to formally introduce Honorable Mr. Justice M.S.Shah sir. Neha ma'am, over to you.
Very good afternoon, sir. Sir was born in Vijapur, Gujarat, son of also a district session judge. He has done his schooling and college from Vadodara, where he obtained his degree in Bachelor of Arts in Political Science with first class and first rank with Aurobindo Prize. Sir started his practice in the Gujarat High Court in 1976, made rapid strides in constitutional, civil, and corporate law matters. He was also a standing counsel for many boards and corporations. Even during busy practice, he did not ignore any academic pursuits. After obtaining LLM degree from Gujarat University, he was part-time lecturer in law colleges as well. Sir was elevated as a judge on the bench of the High Court of Gujarat on September 1995. He has delivered a number of lectures and participated in law conferences and seminars, including international conferences. Sir has also been a visiting faculty at the National Judicial Academy at Bhopal and also at the Gujarat State Judicial Academy at Ahmedabad. He was then elevated as Chief Justice of High Court of Calcutta in December 2009. Sir then assumed the office of Chief Justice of Bombay High Court in June 2010. Sir, without wasting any more time, I would warmly invite you to share your expertise and wisdom on the art of judgment writing with all the participants and students who have joined us on this platform. Sir, please.
Very good morning to you all. Dr. Mayuri Pandya, the director of the center, who is unfortunately not well today and therefore not present, but I convey my greetings to her for organizing this excellent competition. Also, Dr. Vidhi Shah, assistant professor and coordinator of this event, and Dr. Jia Matharani, assistant professor and co-coordinator of this event. All the distinguished faculty members and dear participants and other law students. It's a pleasure to be in the midst of young legal minds who will be the future of the legal fraternity of tomorrow. Law as a career offers a myriad of opportunities, and no doubt it is one of the most sought after career options for the youth in the present days. Many of you will go on to become arguing counsel in courtrooms, in-house lawyers, uh, corporate lawyers. Many of you will go on to become arguing counsel and in various courts. Some of you may become career bureaucrats, and some of you will also adorn the bench of the judiciary in various parts of the country. Competitions such as judgment writing competition helped the students to get a glimpse and idea of the practicalities of the legal profession. Hence, students are, your generation is really fortunate in having these opportunities which our generation did not have. So I'm sure that you all will pursue this and avail of this opportunity with full vigor and with utmost sincerity. Friends, India is the largest democracy in the world, and now it has assumed leadership role in the entire world. So the entire world is now looking to India for leadership in legal field and judicial field as well. In this background, the present judgment writing competition assumes great significance as it seeks to equip the bright young minds with skills to write a judgment which can effectively communicate the intent and reasoning of the bench while not confounding or confusing the readers by using very complex language. Why I am starting with this thought first? Because the important thing is that judgment should be easily comprehensible to the people whose life and affairs are going to be affected by the outcome of the case. And not only by the outcome of this one particular case, but by the operation of our legal system generally. Friends, we all know that more than 90% of the people in our country cannot read or speak English. That means your audience is going to be limited to only 10% of the country. You must have read recently that on the Republic Day, the Honorable Chief Justice of India announced that more than 1,000 judgments will be released in regional languages. See, it is very necessary to see that law and courts as an institution are able to retain their link with the society. They must have that rapport with the society which will enable them to earn the trust of the society, because judiciary is one institution which is not elected by the electorate at the elections. It enjoys respect as an institution because of the trust that it earns from that, the trust that it has from the people. Therefore, it is very necessary for judges writing the judgments to see that their judgment is comprehensible. It is necessary to have lucid language as far as possible. We come across judgments which sometimes are written in such complex language that most of the people who read them, including judges and lawyers, other judges and lawyers, may not be able to understand them. Very recently, I mean, in the year 2022, there was a case where judgment of a high court was written in such language. The one sentence itself ran into one full page, and the Honorable Supreme Court set aside that judgment and gave a very illuminating advice and suggestions how to write judgments. That was the case of State Bank of India in the year 2022. Now, friends, let me tell you that very often people in the legal profession take pride in using very complex language. For instance, if I give you an orange, what will an ordinary person say? That I have given one orange to you. But if a lawyer were asked to draft the conveyance, show the transfer of ownership, what will the lawyer write? He will write something like this: know all the persons by this presents that I hereby give, grant, bargain, sell, release, convey, transfer, and quit claim all my right, title, interest, benefit, and use whatever in, of, and concerning this chattel known as an orange or citrus aurantium, together with all the appendices thereto of skin, pulp, pip, rind, seeds, and juice, to have and to hold the said orange together with its skin, pulp, pip, rind, seeds, and juice for his own use and behalf, to himself and his heirs, in fee simple forever, free from all liens, encumbrances, easements, limitations, restraints, or conditions whatsoever, and any and all prior deeds, transfers, or other documents whatsoever, now or anywhere made, to the contrary notwithstanding, with full power to bite, cut, suck, or otherwise eat the said orange, or to give away the same, with or without its skin, pulp, pip, rind, seeds, or juice. Now, using language like this is going to confound and confuse anyone and everyone who reads it. That is why it is important for us to realize that first and foremost, judgment writing is a skill which which is to be utilized for the purpose of communicating. After all, what is a judgment? Civil Procedure Code defines judgment as the reasons for the decision being given by the court. So the judge speaks through the judgment. Very often we find in the newspapers that there are some observations which the honorable judges make in the course of hearing a case, and the newspaper reporters are very prompt in reporting those observations. But ultimately, when you find that the court has decided a case and given a judgment, you will find that all those observations which were orally made are not there in the judgment. So a judge always speaks through his judgment, and therefore it is necessary for any person interested or in developing the skill of judgment writing to remember that the judgment is in print, in ink, is going to remain forever, and therefore the language to be used in the judgment should be very restrained, very responsible, and very decent. Confidence in judicial process is predicated on the trust which its written word generates. This is what the Honorable Supreme Court said in that recent judgment. If the meaning of the written word is lost in language, that is complex language, the ability of the adjudicator to retain the trust of the reader is severely eroded. Now, the Honorable Supreme Court has further said that untrained in the law, the litigant is confronted with a language which is not heard, written, or spoken in contemporary expression. The purpose of judicial writing is not to confuse or to confound the reader behind the veneer of complex language. The judge must write to provide an easy to understand analysis of the issues of law and fact which arise for decision. While a judgment is read by those as well who have training in the law, they do not represent the entire universe of discourse. As I said, as it is, only 10% of the people in the country are able to read and speak English. And if you use a language which sometimes Mr. Shashi Tharoor uses, I have a great respect for him. He is a very learned person, and I enjoy reading listening to his speeches and reading his articles. But if you use that kind of language, what will happen? Your audience will get restricted, not even to 10%, it will be just less than 1% of the people for whom it is meant. So, therefore, it is very important that we should realize what are the purposes for which the judgment is written. Justice Daphne Barak, areas of the Supreme Court of Israel, emphasize on this aspect of judgment being written in a lucid manner. I quote, For judges, the professional community is only one of their severe audiences, one of their several audiences. Judges write first and foremost for the parties appearing before them, for the state's agents who are in charge of enforcement, and for the public. Although judgments are professional legal documents and sometimes involve complex technical legal analysis, they should also be accessible or at least explicable to people who are not professionals as they define the law for a larger community. Friends, I would request all of you to get hold of a book called Fat Free English. I came across that book some time back and I'm not able to trace it now. But whenever you get that opportunity, you should read that book and you will enjoy it. We all know that obesity is bad for your health, and there are so many diseases which come out of obesity. So, when you consult a dietitian or a nutritionist, she will advise you that don't go for weight loss, go for fat loss, because the idea is that if you lose muscles in the process of losing your weight, you will become very weak and again become susceptible to many diseases. So therefore the important thing is that you must retain and develop and build up your muscles, but you must lose your fat. So similarly, you should continue to have your proper thoughts and contents in the judgment, but at the same time don't use very complex, inexplicable language which only very few people can understand. By writing a judgment, the court communicates its reasoning and decision both on issues of fact and law. A successful communication is one which can be easily understood by its targeted audience. Judgments are also read by litigants who would be innocent to legal terminology and a high-level literary prose. That is why all along we have been emphasizing that the judgment should be written in simple language. Friends, if you want to know how to write a good judgment, you must also once in a while read the judgments of Lord Denning. He was one of the most learned judges, but still the judgments that he wrote were always in simple language. I'll give you just one illustration. It was a case where a gentleman built a house on the edge of a cricket ground and thereafter complained that the cricket ground should be shut down because the game disturbed him and his family. Now you know that generally people are so fond of this game that nobody would take him seriously. But suppose such a person did file a case in a court in England, and Lord Denning used this language for describing the facts of the case. Just see how simple sentences are used by Lord Denning. I quote, "In summertime, village cricket is the delight of everyone. Nearly every village has its own cricket field where the young men play and the old men watch. In the village of Linds in County Durham, they have their own ground where they have played this last 70 years. The wicket area is well rolled and mown. The outfield field is kept short. It has a good clubhouse for the players and seats for the onlookers. The village team play there on Saturdays and Sundays. They belong to a league competing with the neighboring villages. On other evenings after work, they practice while the light lasts. Yet now, after these 70 years, a judge of the High Court has ordered that they must not play there anymore. He has issued an injunction to stop them. He has done it at the instance of a newcomer who is no lover of cricket. This newcomer has built, or has had built for him, a house on the edge of the cricket ground, which 4 years ago was a field where cattle grazed. The animals did not mind the cricket. But now this adjoining field has been turned into a housing estate. The newcomer bought one of the houses on the edge of the cricket ground. So this gentleman, purchased the land which was being used as a grazing field adjoining the cricket ground. No doubt the open space was a selling point. Now he complains that when a batsman hits a six, The ball has been known to land in his garden or on near his house. His wife has got so upset about it that they always go out at weekends. They do not go into the garden when cricket is being played. They say that this is intolerable. So they asked the judge to stop the cricket being played. And the judge, much against his will, has felt that he must order the cricket to be stopped. With the consequence, I suppose, that the Linds Cricket Club will disappear. The cricket ground will be turned to some other use. I expect for more houses or a factory. The young men will turn to other things instead of cricket. The whole village will be much the poorer. And all this because of a newcomer who has just bought a house there next to the cricket ground. Just see how short sentences are being, the judgment is written in such short sentences and simple words without any jargon, without any long winded legal writing. You know exactly what the judge is saying. You understand every word, every sentence of his judgment. You don't need to be a legal expert to understand what the judge is trying to convey. Even a child can understand what he is saying. In doing so, he breaks many conventions but does so beautifully. So that is what the that book says, the Factory English, that you should use language which a 12th standard student can understand, and that will be the best possible way of communicating your reasoning to the people at large and who would like to remember this. Another thing is that when you write a very long judgment, sometimes the subject is so complex, the issues may be serious, touching the economy of the country, that you may have to write a very long judgment. Sometimes the judgment runs into 60, 70 pages, maybe sometimes 100 pages. But in such a case, then you must divide the judgment in proper rational parts and prepare a table of contents, that which issue is discussed in which paragraphs or pages of the judgment. That will give an idea, because very often what happens is that when there is such a long judgment running into 100 pages, people may not be able to go through the entire judgment in one sitting. They may like to read the judgment in parts. If you have a table of contents, then the reader will be able to read it properly and make proper sense out of it. I spoke to you about that judgment of Lord Denning. That is actually a part of his reported judgment. Now, in his autobiography, Lord Denning dealt with this subject in the following words. I quote, I start my judgment with a prologue, as the chorus does in one of Shakespeare's plays, to introduce the story. What is the prologue? You must introduce the story. What is the dispute about? What is the subject? Because if you still simply start with the facts of the case, that so and so was born in the year 1982, and so and he was studied in this college and that college and went on. When you start reading the judgment, you will not be able to know what is the subject, what is the controversy about. So that is why Lord Denning says that I must start with a prologue to introduce the story. I draw the characters as they truly are, using their real names. I avoid long sentences because they lead to obscurity. It is no good if the reader cannot follow them. I refer sometimes to previous authorities, what the courts have decided in the earlier cases. I have to do so because I know that people are prone not to accept my views unless they have support in the books, but never at much length. Even when you discuss the previous judgments, don't discuss them with so much length that the reader gets lost in those judgments and forgets what is the controversy at hand. I know that people are prone not to accept my views unless they have support in the books, but never at much length, only a sentence or two. I avoid all reference to pleadings and orders. They are mere lawyer stuff. What the plaintiff has said in the plaint, what the defendant has said in the defense statement, you don't have to repeat everything that what they have said. You can only give them a gist of those pleadings. They are unintelligible to everyone else. I finish with a conclusion. Again, as the chorus does in Shakespeare, in it I gather the threads together and give the result. So when you write a judgment running into 50, 60 pages, the reader is not going to remember everything that you have said. So you should give them a summary of your findings and then the final operative order. Now that operative order should be such, drafted in such a manner that again people are able to understand it, and also it can be enforced and executed. Because if you write a very vague order which cannot be enforced, then the judgment will not make any sense. Now, how exactly do you structure them? There is a formula in this Supreme Court judgment in the case of State Bank of India and another versus Ajay Kumar, Sood. The court has made this important observations which you should remember. In terms of structuring judgments, it would be beneficial for courts to structure them in a manner such that what are the four key words? Issue, rule, applicable, and conclusion are easily identifiable. What do you mean by this? IRAC, this is the formula, issue, rule, application, and conclusion. The issue refers to the question of law that the court is deciding. A court may be dealing with multiple issues in the same judgment. Identifying these issues clearly helps structure the judgment and provides clarity for the reader on the specific issue of law being decided in a particular segment of a judgment. Then what is rule? The rule refers to the portion of the judgment which distills the submissions of counsel on the applicable law and doctrine for the issue identified. That means you analyze the arguments of the lawyer and then apply them to the facts. Then you decide what is the correct interpretation and then apply them to the facts of the case. This rule is applied to the facts of the case in which the issue has arisen. The analysis recording the reasoning of a court forms the application section. So this is also very important, because what is the correct interpretation? When you decide this, you have to give reasons why. Therefore, you will have to analyze the statutory provisions. You have to analyze the previous judgments and the arguments of the counsel. So the analysis recording the reasoning of a court forms the application section. Finally, it is always useful for a court to summarize and lay out the conclusion on the basis of its determination of the application of the rule to the issue along with the decision vis-a-vis the specific facts. So your final order, the operative order, should also be comprehensible, readable, and enforceable. This allows stakeholders, especially who are the stakeholders? The parties, their lawyers, the witnesses, and the world at large, especially members of the bar as well as judges relying upon the case in the future to concisely understand the holding of the case. So you think that you have explained the law in the best possible manner, but the question remains whether the people who will be reading your judgment in future, will they be able to say that this is what the judge has said? In this day and age of internet, information on each and every topic is available in aplenty. However, you must remember this, that while relying upon sources of information available online, you must be careful and not to rely upon all of them. Recently, the Honorable Supreme Court, in the judgment in HP India Sales Private Limited versus Commissioner of Customs, has advised the courts and tribunals not to rely on Wikipedia. So, friends, the judgment your judgment should have these three important features: brevity, simplicity, and clarity. I genuinely urge all of you to read voraciously not only the laws that you study, but also on various other also various other subjects like history, economics, literature. Very often it is said that you are not a complete lawyer or a complete judge if you do not read literature, because it is literature which makes life interesting. And therefore, if you want to make your judgments interesting, you must see that you keep reading literature and also other socio-economic subjects and social sciences like economics, political science, sociology. They will make your judgments richer in contents as well. So friends, I wish you all the best, and I hope that uh, some of you, or at least many of you, should join the judiciary as and when you complete your studies and join the legal profession. Whenever there is a call of duty, when you are practicing, and the High Court or the District Court request you to accept judgeship, please consider it as a call of duty, and don't look at it in terms of the monetary remuneration, because the satisfaction that you will get as a judge, which will be much, much greater than any monetary remuneration that you can get as a lawyer. So I wish you all the best, and thank you so much for giving me a patient hearing. I wish you all the best. Thank you.
Thank you so much, sir. Sir, you enlightened the viewers with the different skills of judgment writing, how to interpret the law, how to interpret the facts, and also we are very sure that the viewers and the participant would have enlightened. And the best part is, sir has explained about the online and offline, online pros and cons of the internet material which we are using. All the budding advocates, for them it would be a great help. Now, sir, we will take 5 minutes for the open floor, and
Okay.
those who want to ask any question, and then
Okay, sure.
we will declare the prize for which the participants are eagerly waiting. And
Okay,
sir, to
sure.
appraise you, there were 24 teams who had participated. In the one team there were two students who had written the judgment, and the various national law university and the prestigious universities had participated. Yes, over to you, Neha ma'am. Any questions if the participants or the viewers have, you can ask the sir.
Uh, yes. With the permission of the Lordship, could we take one or two questions from the students?
Sure. Sure. Sure.
Neha ma'am, you can ask the sir. Sir will answer all the queries of the students.
They are sending it through chat box.
Yes,
How?
sir. I think the internet connectivity is.
So,
इंटरनेट सरने पण इंटरनेटની રુચિ થઈ લાગે છે.
कितनी देर से ऑन करा था?
Sir, with your permission, can we ask?
Am I audible now?
Yes, yes, sir. Yes,
Okay.
sir.
Yes, sir. Sir,
Yes,
you're
Neha.
audible. Okay, sir. Sir, student has asked, how does the diversity of opinion be managed while delivering a judgment as part of a division bench?
That's a very interesting question. When two judges are sitting together on a bench, they both have their own independent minds, but they also have a dialogue with each other. Sometimes there may be difference of opinion, but it is always, because they are judicially trained minds, therefore they are able to see what is the viewpoint of the other judge, and it is quite easy to reconcile the two most of the time. Sometimes it may happen that they may not be able to agree on the final judgment to be given or the final conclusion to be given. Sometimes they agree with to the conclusion, but they have different reasons. Then they may give different judgments with the same conclusion. But if they don't agree about the conclusion also, then they give two separate judgments, and then the case has to be referred to a third judge. So the matter will be placed before the Chief Justice of the High Court or the principal judge of the court, and he will assign the case to the third judge, who will hear the counsel again and then give his judgment. So then out of 3, which is the view taken by 2 judges, that is by majority, that view will prevail.
Neha ma'am, you are on mute. You are on mute.
Yeah. Sorry, apologies, sir. Sir, there's another question. What is the thought process while dictating the judgment, and are there any other facts that affect the thought process of the judges?
uh, Thought process while dictating the judgment. Well, there are 2 different methods of writing a judgment. It means very often in Gujarat High Court and in Bombay High Court, most of the judges, what they do is that they hear the arguments of counsel, and immediately after the arguments are over, they start dictating the judgment in the open court. So the advantage of this method is that the arguments are very fresh in their mind. The counsel who have argued the case are also present in the court. So in the course of dictating the judgment, if there is any factual error, the counsel can point out that the fact is not this but this. So the judge can correct it immediately. Secondly, because the arguments are fresh and the judge may have made short notes, so he is able to note down those arguments, and a good judge with analytical mind can analyze those arguments on the spot and give the verdict. So this is what we had done as judges of the Gujarat and Bombay High Courts. In more than 90% cases, we gave the judgment immediately, because when the arguments are going on, that time itself you can evaluate the merit of the argument. So if you have any doubt, you can always ask the counsel that to clarify his argument, or if you believe that his argument is not very sound, you can immediately ask him, but this does not appear to be a sound argument, and then the counsel can find out can think of a better argument, and then try to persuade the judge to accept his argument. But there is the other method, is that you hear the arguments and then reserve the judgment. So when you reserve the judgment, you get a lot more time to go through the papers and then think about it, give a thought, what should be the decision, and then start dictating the judgment. But the disadvantage in this process is that the arguments may not remain fresh. There are cases which involve very serious questions of constitutional interpretation. So in such cases, the court may like to reserve the judgment and say that, well, we will give a thought to it. Writing a judgment like Keshwanand Bharti case obviously could not have been done immediately after hearing the arguments. There the judges had to give a very serious thought to all the arguments about the constitutional interpretation and the basic structure of the constitution. So judgments in important cases like this have to be reserved and given later, and then the judges can discuss with each other what is the decision to be given. Yes, please.
Sir, there's just one more question that just popped up. So, if you allow, can we take that last question
Sure,
from this?
sure.
Okay. Sir, a student has asked, how should we clarify our doubt on different jurisdictions of High Court, uh, especially civil original jurisdiction, because it's really confusing for them to find relevant provisions on the topic. So usually when students are going for moot courts or preparing for briefs with the internship, so they have problems. So they wanted to ask this out from you, sir.
Can the student clarify a little more? How should we clarify our doubt on different jurisdiction of High Court, especially civil original jurisdiction? Because it is legally confusing to find a relevant provision on that topic. Can the student join us, or can he ask us clarify that question?
So actually, the students have asked the questions via YouTube, so they are not here with us on the StreamYard platform, sir.
Okay. Very few. There are only 4 high courts which have original jurisdiction in India. These are the chartered high courts of Bombay, Calcutta, Madras, and well, of course Delhi also has a original jurisdiction. So there are laws, legislations. One is the charter of the High Court, which is known as the latest patent. That latest patent defines what is the jurisdiction of the High Court on the original side. Then the parliament or the state legislatures can also make laws on that. For instance, in the state of Maharashtra, there is an act made by the Maharashtra legislature, which says that cases with value up to rupees 1 crore will go to the city civil court, and cases with valuation above rupees 1 crore will go to the high court. At the same time, if the case pertains to a probate claim or arbitration or intellectual property, then it has to go to the Bombay High Court on the original side. It will not go to the city civil court there. So you must study this, the basic documents by which the jurisdiction of the High Court is governed, like the latest patent, like the Bombay City Civil Court Act, and the amendments to the Act. Yes, please.
Uh, Thank you so much, sir, for your
Okay.
expertise and views to share with the students.
Thank
Uh,
you. Thank you.
Nidhi ma'am, over to you.
Yeah. Sir, now we will declare the winners. But before that, sir, I would like to appraise you that the evaluation which is done is purely on the team code. So the
Yes.
honorable judge who has evaluated, he also had judgments based on the team code. And now Lordship may declare the winners with the team code and the name of the college.
Okay. Acha, team
So
code is
here
also.
we are, yes. So here we are with the most awaited moment. The participant had tried their best, has written. We had got a view by the honorable judge that there are few teams who have written exceptionally well as per the given format of the judgments, and there were few who had required some improvement, but none of the team was had written with not with the format, and number of things which were required in the judgment were included. So appreciation from the judge who has evaluated the judgments.
Okay.
Over to you,
Okay.
sir.
Okay. So I am supposed to announce the results now.
Yes, sir. From the
Okay.
second runner up we will go, sir.
Yes. Yes. Yes.
Yes.
The winners of the virtual national judgment writing competition are, second runners up are TM2, Savitha School of Law, Chennai. Okay. The first runners up are team is TM17, Campus Law Center, Faculty of Law, Delhi University. And you are all anxiously waiting for announcement of the winner. Well, the winner is TM23, Himachal Pradesh National Law University, Shimla. A big applause.
uh, Thank you so much,
Well,
sir.
the other participants, those who may not have won any prize, but still I would like to congratulate them for participating in this competition, because it is participation in competition which is important, which keeps your spirits alive, and wish you all better luck next time. But it's not just better luck, you will have to work harder next time and see that you master the skill of judgment writing.
Thank you so much, sir. With your guidance, we are sure they will be doing better next time. Uh, Over to Neha, ma'am, for the formal vote of thanks.
Uh, Thank you, ma'am. Thank you, Honorable Mr. Justice M.S. Shah, for sharing his time, his expertise with all the students and all the participants. I'm sure that they have learned quite a bit on how to write the mistakes that they made and things to do better for the next competition. I also extend my heartfelt gratitude to Honorable Mr. Justice A.L. Dave, sir, for providing his time in judging the judgments that we received and providing notes to the students so that they can do better in the next competition. My also heartfelt gratitude to the director of JLS Law College, Dr. Mayuri Pandya ma'am, for her constant support in every endeavor that we do. Further, I'm thankful to the entire teaching and non-teaching staff of Faculty of Law, GLS University, who are always with us for every single competition that we do here. My heartfelt thanks to all the participants of National Judgment Writing Competition for their enthusiasm in submitting the judgments. Uh, Thank you to all the viewers who have joined us today for this ceremony. And thank you once again to each and one of you for this competition. Thank you.
Thank you. Thank you.
Thank you, sir. Thank you so much.
Thank you.